I'm Joel Ankney. I'm a lawyer who helps people buy and sell small businesses, and I'm the author of the book, Here's the Deal, Everything You Wish a Lawyer Would Tell You About Buying a Small Business. Earlier this year, I was invited to speak to the Entrepreneurship Through Acquisition class at the Columbia Business School about the legal process of buying a small business. And I'm making this video to share with you the presentation that I gave to the ETA class because I think the information is relevant for anybody who's thinking about buying or even selling a small business. Once the buyer has made it through due diligence without terminating the transaction based on their due diligence findings, they've decided to move forward with the transaction, then I become much more involved in the transaction, and what I do at that point is I draft a purchase agreement, an asset purchase agreement. The asset purchase agreement is a lengthy legal document. It's the most significant document that's going to be drafted for the transaction, and we're going to focus on a couple of things from the buyer's perspective when we draft the asset purchase agreement. One of the things we're going to focus on is the description of the assets that are being purchased. We want to make sure that we're getting everything we're paying for. We're also going to be looking closely at the purchase price and how the purchase price is calculated and adjusted and paid. This is where we're going to have provisions about adjusting for the value of inventory at closing, for example. And this is also where we're going to talk about paying cash for a portion of the purchase price at closing and then describing the seller financing if there is any. The purchase agreement will also indicate the contingencies that have to be met before closing can happen. For example, one of those contingencies may be obtaining consents from landlords and other contract holders to the transfer of the assets. Another contingency might be closing on the loan to fund the cash portion of the purchase price. A significant portion of the asset purchase agreement will be the representations and warranties and the indemnification provisions. The representations and warranties are factual representations and promises made by the seller about the business. They'll cover everything from the organization of the business to employees to material contracts to intellectual property, environmental matters. What we're trying to do here is we're trying to make sure that the seller tells us everything they know about the business and remains liable and responsible for any claims that arise prior to closing, even if they arise after closing. The seller's representations and warranties are also going to require that the seller draft disclosure schedules. The disclosure schedules will be attached to the asset purchase agreement before it's signed. And in the disclosure schedules, the seller will have an opportunity to identify and describe any exceptions to the representations and warranties, and will also be asked to list significant factual information about the business. The disclosure schedules are a very important part of the asset purchase agreement because they protect both the buyer and the seller. The indemnification provisions are there to protect, again, both the buyer and the seller for claims that one party is responsible for, but that are brought against the other party. For example, the seller will be responsible for pre-closing liabilities, even if they arise after the closing. So if, for example, a creditor of the seller makes a claim against the buyer after closing for a liability that arose prior to closing, the seller promises that they will reimburse or defend the buyer, make them whole, so that the buyer won't have to be responsible for that particular liability. That just makes sense. That's fair. And the buyer will make similar promises in the indemnification provisions to protect the seller from any claims that arise after closing for the buyer's operation of the business or in connection with the buyer's operation of the business after closing. In some transactions, when the buyer is perhaps not comfortable that the seller will have the resources necessary to cover an indemnification claim after closing, the buyer may ask the seller to leave a portion of the purchase price in escrow after closing. So for example, in a transaction with a purchase price of say $2 to $3 million, the buyer may ask the seller to leave $100,000 or more in an escrow after closing for a period of time, maybe 12 months, maybe 18 months, so that if the buyer has an indemnification claim against the seller, it can make that claim against the escrow. It can get paid out of the escrow money rather than relying on the the seller to have to come up with the money on its own after closing. The purchase agreement will also address things that will happen after closing. So, for example, there will be a non-compete restriction that will prevent the seller from competing against the buyer's business after closing. There will also typically be a provision that requires the seller to provide transition services to the buyer for a short period of time after closing. Thank you for watching my presentation. If you have more questions or want to learn more about the process of buying or selling a small business, you can see my contact information here on this last slide. If you want to buy my book or listen to the audiobook, you can find the print book on Amazon and the audiobook on Audible. I also maintain a blog at my website, so if you have other questions, you might look there first to see if you can find an answer there. Thanks.